A legal citation signal or introductory signal is a set of brief abbreviated phrases or words used to clarify the authority or significance of a legal citation as it relates to a proposition. They are used in legal citations to present authorities and show how the authorities relate to propositions in textual statements. Legal writers use introductory signals to tell readers how the legal authority citations support, or do not support their written propositions. Introductory signals organize the writer's citations into a hierarchy of strength and importance so that the reader can quickly determine the relative weight of the citation. Signals help a reader quickly discern meaning or usefulness of a particular reference when the reference itself does not provide adequate information. Introductory signals have different meanings in different U.S. citation style systems. The two most prominent citation manuals are the Bluebook, a Uniform System of Citation, and the ALWD Citation Manual. Some state-specific style manuals also provide guidance on legal citation. The Bluebook citation system is both the most comprehensive and most widely used system by courts, law firms, and law reviews. Here are examples, with explanations, of the introductory signals used in legal writing under the Bluebook system. Usage: most citation signals are placed in front of the citation to which they apply. For example, in the paragraph, when writing a legal argument, it is important to refer to primary sources. To assist readers in locating these sources, it is desirable to use a standardized citation format. See generally Harvard Law Review Association, the Bluebook, a Uniform System of Citation. Note, however, that some courts may require any legal papers that are submitted to them to conform to a different citation format. The signal is the phrase "see generally," which indicates that the citation. The Bluebook, a Uniform System of Citation, provides general background information on the topic. Signal details. Equals signals that indicate support equals. No signal. When writers use no signal, this tells readers that the cited authority directly states the proposition, is the source of the cited quotation, or identifies an authority referred to in the text. Example: we have consistently applied that presumption to language in the ADEA that was derived in Hague Verba from Title VII. Lorillard v. Pons, 434 U.S. 575, 584, 55 L. 2d 40, 98 SCT 866. Example: the court points out that the proper role of the trial and appellate courts in the federal system in reviewing the size of jury verdicts is a matter of federal law. Gasparini v. CTR for Humanities, 518 U.S. 415. Example: Bilader was prosecuted in state court for the misdemeanor offense of possessing the raccoon without a permit. R.I. General Laws, January 20, 16. Example: the idea was enacted to ensure that all children with disabilities have available to them a free appropriate public education at €20 USC. A Section 1400, d. 1, a. Example: in Idaho, ephedrine was listed as a Schedule II substance in the Uniform Controlled Substances Act in 1988. I.C. A Section 37 to 2707, g. 1, b. Example: it must be remembered that the right of suffrage can be denied by a debasement or dilution of the weight of a citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise. Reynolds v. Sims, 377 U.S. 533, 555, 12 L. ed. 2d 506, 84 S. Connecticut, 1362. Example: the manner, method and time of such extinguishment raise political, not justiciable, issues. United States v. Santa Fe Pacific Car Company, 314 U.S. 339, 347. Example: a criminal defendant is entitled to jury instructions that accurately state the law, permit him to argue his theory of the case, and are supported by the evidence. State v. Staley, 123 Wash 2d 794, 803, 872 pages 2d 502. Example: the corrective action included a directive requiring Staub to report to Mullally or Karenchuk a when, he ha, d, no patients and, the angio cases, we recomplete, d, a unregistered trademark a id, at 653. Example, whether or not the court properly instructed the jury to consider Mr. Karistein's reasonable belief of Misselstad's capacity to consent is a question of law that we will review de novo. State v. Tor. 127 Wash 2d 628, 656, 904 pages 2d 245. Example, the right to counsel plays a crucial role in the adversarial system embodied in the Sixth Amendment, since access to counsel's skill and knowledge is necessary to accord defendants the ample opportunity to meet the case of the prosecution to which they are entitled. Adams v. United States ex rel. McCann, 317 U.S. 269. For example, the signal, an abbreviation of the Latin phrase exempli gratia, means for example. It tells the reader that what the writer is citing directly supports the proposition, but there are other authorities which also support the proposition, but their citation may not be as useful or necessary. This introductory signal may be used in combination with other signals, preceded by an italicized comma. Note, the comma after for example, is not italicized when attached to another signal, but is italicized when for example appears alone. Example, parties challenging state abortion laws have sharply disputed in some courts the contention that a purpose of these laws, when enacted, was to protect prenatal life. See, for example, Abel v. Markle, 342 F sub 800, appeal docketed, number 72-56. Example, the Code, as long interpreted, vests this court with sole authority to review state court judgments. For example, Feldman v. Citation omitted, 460 U.S., 476, 75 L. 2d 206, 103 S. Connecticut, 1303 Atlantic Coastline UCO v. Locomotive Engineers, 398 U.S. 281, 286, 26 L. 2d 234, 90 S. Connecticut, 1739. Rooker v. Citation omitted, 263 U.S., first page, 416, 68 L. ed. 362, 44 SCT 149. Example, unfortunately, hiring undocumented laborers is a widespread industry practice. For example, Transamerican's Company v. Bellefontaines Company, 548 F sub 1329, 1331. Example, other circuits have made that leap. See, for example, Arnold, 421 F3D at 870 and N1. Example, the placebo effect is well established. See, for example, Anne Harrington, the placebo effect, an interdisciplinary exploration. Example, in other cases, we did not articulate any standard at all, granting reimbursement automatically after determining that the school district failed to provide a free appropriate public education and that the student was placed in an appropriate private school. See, for example, Capistrano, 59 F3D at 896-97. Union SCH. Dist. B. Smith, 15 F3D 1519, 1527. Example, nevertheless, the Due Process Clause protects property interests. And while the notion of property interest has been stretched quite far in certain contexts, for example, Goldberg v. Kelly, 397 U.S. 254, it depends importantly on what interests are recognized under state law. Example, moreover, to the extent that exhausted and unexhausted claims are interrelated, the general rule among the courts of appeals is to dismiss mixed habeas petitions for exhaustion of all such claims. See, for example, Triplett v. Wyrick, 549 F2D 57. Miller v. Hall, 536 F2D 967. Hewitt v. North Carolina, 415 F2D 1316. Example, unlike the confrontation clause, those provisions are of no use to the defendant when the witness is unavailable or simply refuses to appear. See, for example, Davis, 547 U.S., at 820, 126 SCT 2266. Example, the court has considered Sixth Amendment claims based on actual or constructive denial of the assistance of counsel altogether, as well as claims based on state interference with the ability of counsel to render effective assistance to the accused. For example, United States v. Cronic, 466 U.S. 648, 104 SCT 2039, 80 ALWD 657. Accord. Accord is used when two or more sources state or support the proposition, but the text quotes or refers to only one. The other sources are then introduced by accord. In other words, accord means I have just cited something that supports my proposition, and now here unregistered trademark s another thing that supports it too. Legal writers often use accord to show that the law of one jurisdiction is in accord with that of another jurisdiction. Example, nervousness alone does not justify extended detention and questioning about matters not related to the stop. United States v. Chavez Valenzuela, 268 F3D 719725. Accord. United States v. Beck, 140 F3D 1129, 1139. United States v. Wood, 106 F3D 942, 248. United States v. Tapia, 912 F2D 1367, 1370. Example, rather, our inquiry is limited to whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. Jackson v. Virginia, 443 U.S. 307, 319. Accord. People v. Cox, 195 L2D 378, 387. Example. The term Fifth Amendment in the context of our time is commonly regarded as being synonymous with the privilege against self-incrimination. Quinn v. United States, 349 U.S. 155. 163, 75 SCT 668, 99 LED 964. Accord. and re Johnny v. 85 Calories App 3D 120, 149 Cal RPTR. 180, 184, 188. Example. This court has repeatedly held that the pendency of an action in the state court is no bar to proceedings concerning the same matter in the federal court having jurisdiction. McClellan v. Carland, 217 U.S. 268, 282, 54 LED 762, 30 SCT 501. Accord. Doran v. Salem Inn, Incorporated, 422 U.S. 922, 928, 45 LED 2D 648, 95 S. Connecticut, 2561 Atlantic Coastline UCO, 398 U.S., at 295, 26 LED 2D 234, 90 S. Connecticut, 1739. Example. The primary objective of copyright is not to reward the labor of authors, but to promote the progress of science and useful arts. Art I, 8, CL 8. Accord. 20th Century Music Corporation v. Aiken, 422 U.S. 151, 156. Example. It is well settled that illegally obtained statements are admissible for the purpose of impeachment. See United States v. Havens, 446 U.S. 620, 626-27, 100 SCT 1912, 64 LED 2D 559. Accord. State v. Griff, 67 Wash. App 166, 834 pages 2D 656, review denied. 121 Wash 2D 1005, 848 pages 2D 1263. Example: this objective will only be satisfied if the court can, from the application and accompanying documentation itself, pass on all aspects contained therein. 8 Accord, Chicago Lutheran Hospital, Supra at 735. Example: Accord, Swakayaich, 534 U.S., at 514, 122 SCT 992. National Organization for Women, Incorporated v. Heidler, 510 U.S. 249, 256, 114 SCT 798, 127 LED 2D 99. H.J. Incorporated v. Northwestern Bell Telephone Company, 492 U.S. 229, 249 to 250, 109 SCT 2893, 106 LED 2D 195. Hishan v. King and Spalding, 467 U.S. 69, 73, 104 SCT 2229, 81 LED 2D 59. Example: the following authorities held, prior to Crawford, that the Confrontation Clause does not require confrontation of certificates stating that instruments were in good working order at the time of a test. State v. Ing. 53 Hall 466, 467 to 473, 497 pages 2D 575, 577 to 579. Accord, State v. Offer, 9 Hall App 130, 135 to 139, 828 pages 2D 813, 817 to 818. C equals, a OE Euro indicates that the cited authority clearly supports, but not directly states the proposition given. Used instead of, no signal, to indicate that the proposition follows from the cited authority. There is an inferential step between the authority cited and the proposition it supports. C may also be used to refer to a cited authority that contains dicta in support of the proposition being made. Example: at this time, the AEDPA one-year statute of limitations had run. C. Duncan v. Walker, 533 U.S. 167, 181 to 182, 150 LED 2D 251, 121 S. Connecticut, 2120. Example: similar questions have arisen under the Federal Endangered Species Act. C. For example, United States v. Winnie, 97 F3D 975. Example: before 1997, the idea was silent on the subject of private school reimbursement, but courts had granted such reimbursement as a OE appropriately a relief under principles of equity pursuant to 20 U.S.C. A Section 1415, I, 2, C. C. Burlington, 471 U.S. at 370, 105 SCT 1996. 20 U.S.C. A Section 1415, I, 2, C. Example: although this standard requires us to give considerable deference to the state courts, AEDPA deference is not a rubber stamp. C. Miller L.V. Dretk, 545 U.S. 231, 240, 265, 125 S. Connecticut, 2317, 162 LED 2D 196. Example: relying upon NAACP, we concluded that the South Carolina Supreme Court's interpretation of a state penal statute had impermissibly broadened the scope of that statute beyond what a fair reading provided, in violation of due process. C. 378 U.S. at 361 to 362. Example: the determination of a euro in euro is a euro a mixed question of law and fact a C in Riesbader, 903 F2D 971, 975. Example: the soil, to which the Crown originally claimed title, being no longer occupied by its ancient inhabitants, was parcelled out according to the will of the sovereign power, and taken possession of by persons who claimed immediately from the Crown, or mediately, through its grantees or deputies. Pages 590 to 591. See Butts v. Northern Pacific R Company, 119 U.S. 55, 66. Martin v. Waddell, 16 Pet 367, 409. Clark v. Smith, 13 Pet 195, 201. Example: the Supreme Court appears to suggest the more stringent reasonable doubt standard may apply when the inference is the a sole and sufficient basis for a finding of guilt Ulster, 442 U.S. at 167, 99 SCT. At 2230. Division 2 of the Court of Appeals has so held. See State v. Delmorter, 68 Wash. App 770, 784-85, 845 pages 2d 1340. Example: there is no inconsistency between Mr. Coristine's defense theories and therefore no prejudice attends the affirmative defense. See State v. Jones, 99 Wash 2d 735, 748, 664 pages 2d 1216. Example: the right to counsel plays a crucial role in the adversarial system embodied in the Sixth Amendment, since access to counsel's skill and knowledge is necessary to accord defendants the ample opportunity to meet the case of the prosecution to which they are entitled. Adams v. United States ex rel. McCann, 317 U.S. 269, 1942. C. Powell v. Alabama, Supra, 287 U.S. at 68-69, 53 SCT 63-64. See also equals. This indicates that the cited authority constitutes additional material that supports the proposition. The cited authority supports the proposition with which the citation is associated, but less directly than that indicated by C, or accord. C also may be used to introduce a case that supports the stated proposition, but is somehow distinguishable from previously cited cases. C also is sometimes used to refer readers to authorities that support a proposition when other authorities that support the proposition have already been cited or discussed. The use of a parenthetical explanation of the source's relevance following a citation introduced by C is also encouraged. Example: omitting the same mental element in a similar weapons possession statute, such as RCW 9.41.040, strongly indicates that the omission was purposeful and that strict liability was intended. See generally State v. Alvarez, 74 Wash. App 250. 260, 872 pages 2d 1123 AFAD, 128 Wash 2d1, 904 pages 2d 754. See also State v. Roberts, 117 Wash 2d 576, 586, 817 pages 2d 855. Source: State v. Anderson, 141 Wash 2d 357, 5 pages 3d 1247, 1253. Example: see also Martin v. Wilkes, 490 U.S. 755, 784 N21, 104 L. Ed. 2d 835, 109 S. Connecticut, 2180. Example: see also Eolas Technologies Incorporated v. Microsoft Corporation, 399 F3D 1325, 1339. Example: in Ash, the disabled student attended private school beginning in 1983, but his parents did not provide meaningful notice to the school district until 1989. Ash v. Lake Oswego SCH. Dist. Number 7J, 766 F Sup. 852, 853-55, 864. See also Ash, 980 F2D at 586. Example: the Supreme Court of Florida has said that the legislature intended the state's electors to participate fully in the federal electoral process, as provided in 3 U.S.C. 5. 779 So 2D at 270. See also Palm Beach Canvassing BD. B. Harris, 772 So 2D 1273, 2000 WL 1,725,434. Example, bankruptcy court held debtor entitled to entire $7,500 exemption as representing compensation for bodily injury or loss of future earning capacity. See also, in Re column, 612 So 2D 572, 574. Example, whether an inference meets this standard must be determined on a case-by-case basis in light of the particular evidence presented to the jury in each case. See Ulster, 442 U.S. at 162-63, 165, 99 SCT. At 2227-28, 2229. Francis, 471 U.S. at 314-15, 105 SCT. At 1971. See also Schwindemann v. Wallenstein, 971 F2D 313, 316. Crowley v. Winans, 920 F2D 454, 456. Example, a defendant is entitled to a diminished capacity instruction when he produces expert testimony establishing that he suffered from a mental disorder, and the evidence logically and reasonably connects the defendant's alleged mental condition with the inability to possess the required level of culpability to commit the crime charged. State v. Griffin, 100 WN2D 417, 418 19, 670 pages 2D 265. See also Cienfuegos, 144 WN2D a 227. State v. Ellis, 136 WN2D 498, 521, 963 pages 2D 843. Example, the court indirectly recognized as much when it stated in Macman v. Richardson, Supra, 397 U.S., at 770, 771, 90 SCT, at 1448, 1449, that a guilty plea cannot be attacked as based on inadequate legal advice unless counsel was not a reasonably competent attorney and the advice was not within the range of competence demanded of attorneys in criminal cases. See also Kyler v. Sullivan, Supra, 446 U.S., at 344, 100 SCT, at 1716. CF This signals that the cited authority states a proposition different from the main proposition but sufficiently analogous to lend support. Writers use this signal when the cited authority does unregistered trademark T exactly support what they have said, but E to unregistered trademark S close enough to lend support. An explanatory parenthetical is strongly recommended, otherwise the citation's relevance may not be clear to the reader. Example, it is precisely this kind of conjecture and hair-splitting that the Supreme Court wanted to avoid when it fashioned the bright-line rule in Miranda. C.F. Davis, 512 U.S. at 461. Example, it would be destructive of time and energy for all concerned were we to rule otherwise. C.F. Doe v. Bolton, 410 U.S. 179, 93 SCT 739, 35 LED 2D 201. Example, when a limited remedy is non-exclusive, it is harder to say the limited remedy failed of its essential purpose because resort to other remedies is available under the contract. C.F.J. White and a Summers 12-10 question whether exclusive remedy fails of essential purpose. Example, C.F. Nebier v. People of State of New York, 291 U.S. 502, 54 SCT 505, 78 LED 940. Example, the question of mootness is itself a question of constitutional law. C.F. Linary v. Jafco. Incorporated, 375 U.S. 301, 304 A. Sec. Davis v. Weckersler, 263 U.S. 22, 24. Matter of Rosenbluth v. Finkelstein, 300 NY 402 at 404. Example, that practice reflects our understanding that the decisions of state courts are definitive pronouncements of the will of the states as sovereigns. Cf. Erie Company v. Tompkins, 304 U.S. 64, 82 ALWD 1188, 58 SCT 817. Example, given this option to reinstate the contract on its original terms when a plan is proposed, it may be anomalous to require the payment of interest at a market rate while a case is pending. Cf. in Re Hewitt, 16 BR. 973, 980. Example, each case must be scrutinized on its particular facts to determine whether a trial error is harmless error or prejudicial error when viewed in the light of the trial record as a whole, not whether each isolated incident viewed by itself constitutes reversible error. United States v. Grunberger, 431 F2D 1062, 1069. Cf. United States v. Socony Vacuum Oil Company, 310 U.S. 150, 240, 60 SCT 811, 852, 84 ALWD 1129. Example, Cf. Wilson v. Lane, 526 U.S. 603, 609, 119 SCT 6092, 143 ALWD 2D 818. Example, the Massachusetts Court of Appeals did not reach that question and we declined to address it in the first instance. Cf. Coy v. Iowa, 487 U.S. 1012, 1021-1022, 108 SCT 2798, 101 ALWD 2D 857. Example, with the exception of Kyler v. Sullivan, 446 U.S. 335, 100 SCT 1708, 64 ALWD 2D 333, however, which involved a claim that counsel's assistance was rendered ineffective by a conflict of interest. The court has never directly and fully addressed a claim of actual ineffectiveness of counsel's assistance in a case going to trial. Cf. United States v. Eggers, 427 U.S. 97, 102, n. 5, 96 SCT 2392, 2397, n. 5, 49 ALWD 2D 342. Signals that indicate background material. See generally equals, this signal indicates that the cited authority presents helpful background material related to the proposition. Legal scholars generally encourage the use of parenthetical explanations of the source material's relevance following each authority, using see generally. A writer can use this signal with both primary and secondary sources. Example, see generally Gonzalez v. Whitney and Rainey, 288 SW 45, 48. Example, it is a form of discrimination, because the complainant is being subjected to differential treatment. See generally Olmsted v. LC, 527 U.S. 581, 614, 144 ALWD 2D 540, 119 S. Connecticut, 2176. Example, in the aftermath of the Civil War, there was an outpouring of discussion of the Second Amendment in Congress and in public discourse, as people debated whether 2810 and how to secure constitutional rights for newly free slaves. See generally S. Albrook, Friedman, the 14th Amendment, and the Right to Bear Arms, 1866-1876. Brief for Institute for Justice as Amicus Curiae. Example, see generally Grosjean v. American Press Company, 297 U.S. 233, 245-249, 56 SCT 444, 80 ALWD 660. Schlesinger, Supra, at 67-84. Example, the IEP contains an evaluation of the child's current educational level, a statement of annual goals, a statement of the specific educational services to be provided, a projected timetable of services, and objective evaluative criteria and procedures for determining whether objectives are being achieved. CID. See generally Rowley, 458 U.S. at 181-82, 102 SCT. At 3037-38. Example, petitioners have raised an equal protection claim, in the charge that unjustifiably disparate standards are applied in different electoral jurisdictions to otherwise identical facts. Example, see generally W. Keaton, D. Dobbs, R. Keaton, and D. Owen, Prosser and Keaton on the Law of Torts Section 56. Example, some statutes impose more requirements, for instance by requiring defense counsel to subpoena the analyst, to show good cause for demanding the analyst's presence, or even to affirm under oath an intent to cross-examine the analyst. See generally Metzger, Cheating the Constitution, 59 Vand. L. Rev. 475, 481-485. Signals that indicate contradiction. Contra equals, this signals that the cited authority directly contradicts a given point. Opposition. Contra is used where no signal would be used for support. Example, contra Fort Myers and Company v. Hansen, 588 SW2D 282, 283. Example, before Blakely, courts around the country had found that statutory minimum was the maximum sentence allowed by law for the crime, rather than the maximum standard range sentence. See, for example, State v. Gore, 143 Wash 2D 288, 313-14, 21 pages 3D 262, overruled by State v. Hughes, 154 Wash 2D 118, 110 pages 3D 192. Contra Blakely, 124 SCT. At 2536-37. Example, former SCW 26.50.110, 1, was not a virtuosic specimen of legislative drafting, and there is clearly a reasonable dispute as to what the legislature intended. Bunker, 144 Wash. Appert 413, 183 pages 3D 1086. Contra Madrid, 145 Wash. App 106, 192 pages 3D 909. Hogan, 145 Wash. App 210, 192 pages 3D 915. Example, Contra, Ante, at 690 to 691. Example, see People v. Hilt, 298 Hill App 3D 121, 123, 125-26, 698 NE2D 233, 232 ILDEC 395. Contra Commonwealth v. Garcia, 34 Mass App CT. 645, 647, 650, 614 NE2D 1031. State v. Neth, 165 Wash 2D at 185. Example, because the TIA's language and purpose are comprehensive, arguments based on congressional silence on the question whether the TIA applies to actions that increase monies a state tax system collects are of no moment. Contra, Win, 307 F3D, at 1017, 1018. But C equals, cited authority either contradicts the stated proposition implicitly or contains dicta that contradicts the stated proposition. But C is used where C would be used for support. Example, specifically, under Roberts, there may have been cases in which courts erroneously determined that testimonial statements were reliable. But see Bochting v. Bayer, 418 F3D at 1058. Example, to be sure, it was an individual right not available to the whole population, given that it was restricted to Protestants, and like all written English rights it was held only against the Crown, not Parliament. See Schwerer, To Hold and Bear Arms, The English Perspective, in Bogus 207, 218. But see 3J Story, Commentaries on the Constitution of the United States as Section 1858. Example, but see 418 F3D, at 1058. Example, the Sixth Circuit correctly analyzed each charge as a separate offense for jeopardy purposes and held jeopardy terminated for intentional murder even though a jeopardy on the wanton murder charge may have continued after the trial and successful appeal at 458. But see United States ex rel. Jackson v. Villette, 462 F2D 1041. State v. Wright, 203 pages 3D at 1042, Washington, 2009. Example, the government's suggested approach assumes the validity of their conclusion even before the process of deduction has begun. But see Montana Power Company v. Edwards, 531 F sub 8 to Euro. Example, the federal courts of appeals have reached the same conclusion in applying the federal hearsay rule. United States v. Garnett, 122 F3D 1016, 1018 to 1019. United States v. Gilbert, 774 F2D 962, 965. United States v. Ware, 247 F2D 698, 699 to 700. But see United States v. Oates, 560 F2D 45, 82. But cf equals, cited authority contradicts the stated proposition by analogy. The use of a parenthetical explanation of the source's relevance is strongly recommended. Example, but cf 481 U.S., at 25 to 26, 95 LED 2D1, 107 S. Connecticut, 1519. Example, but cf 995 F2D, at 1137. Example. Courts have discretion to hear at sentencing from any person who might provide useful information, including victims of financial crimes. But cf United States v. Fortier, 242 F3D 1224, cert denied, 534 U.S. 979, 122 SCT 409, 151 LED 2D 310, finding a in absence of authority on the issue of whether counsel for victims can participate in a sentencing hearing, and raising a misgivings about the practice where the government had agreed not to argue for the very issues the victims' counsel did, overruled by statute, 18 U.S.C. A Section 3771, d. 1. Example, implicit in their choice is the distinction between preferential and non-preferential establishments, which the weight of evidence suggests the framers appreciated. See, for example, Laycock, a OE non-preferential aid 902 a 906. Levy 91 a 119. But CFT Curry, the First Freedoms 208 to 222. But should be omitted from, but C, and, but CF, whenever one of these signals follows another negative signal. Example, Contra Blake v. Kyline, 612 F2D 718, 723-24. See Charles Allen Wright, Law of Federal Courts 48. Example, we caution, however, that our analysis might have been different if Lancelotti had shown that anyone had been excluded from jury service by the way the boundaries had been drawn or if he had been tried, over objection, before a jury drawn from a district other than where the crime was alleged to have been committed, or if the clear legislative purpose had not been to create a broader and more representative jury pool. But cf. Laws of 2005, ch. 199, a Section 1. Signals that indicate a useful comparison. Compare with equals. This signal is best used to compare two or more authorities that reach different outcomes as to a stated proposition. Because the relevance of the comparison may not be readily apparent to the reader, the Bluebook strongly recommends adding a parenthetical explanation after each authority. Either compare, or with may be followed by more than one source, using, and between each of them. In legal practice, the writer italicizes a compare, a with, a and a compare must be used with, with the with preceded by a comma. If, and is used, the, and must also be preceded by a comma. Example, to characterize the first element as a distortion, however, requires the concurrence to second-guess the way in which the state court resolved a plain conflict in the language of different statutes. Compare FLA. Stat 102.166, with 102.111. Compare 102.112, 1, with 102.111, 1. Example, one could say that imposing a servitude on Lucas's land is necessary in order to prevent his use of it from harming South Carolina's ecological resources. Or, instead, in order to achieve the benefits of an ecological preserve. Compare, for example, Claridge v. NH Wetlands BD, 485A2D 287, 292, with, for example, Bartlett v. Zoning Common of Old Lyme, 282A2D 907, 910. Example, compare Guarantee Trust Company v. York, 326 U.S. 99, 105 to 107, 65 SCT 1464, 1467 to 1469, 89 LED 2079. 2007 with Holmberg v. Armbrecht, 327 U.S. 392, 395, 66 SCT 582, 584, 90 LED 743. Example, a fifth state, Mississippi, excuses the prosecution from producing the analyst who conducted the test, so long as it produces someone. Compare Barnett v. State, 481 SO 2D 788, 792, with McGowan v. State, 859 SO 2D 320, 339 to 340. Using signals as verbs, in footnotes, signals may function as verbs in textual sentences. This allows material that would otherwise be included in a parenthetical explanation to be more cohesively integrated. When used in this manner, signals should not be italicized. For example, see Christina L. Anderson, comment, Double Jeopardy, The Modern Dilemma for Juvenile Justice, 152 U. Par L. Rev. 1181, 1204-07. Becomes, see Christina L. Anderson, comment, Double Jeopardy, The Modern Dilemma for Juvenile Justice, 152 U. Par L. Rev. 1181, 1204-07, for a discussion of restorative justice as a reasonable replacement for retributive sanctions. Cf becomes compare, and for example becomes for example, when these signals are used as verbs. Signal formatting. Capitalizing signals equals, the first letter of a signal should be capitalized when it begins a citation sentence. However, if the signal is within a citation clause or appears within a citation sentence, it should not be capitalized. Signal placement and typeface equals, one space should separate an introductory signal from the rest of the citation, with no punctuation in between. Example, see American Trucking Associations v. United States EPA, 195 F3D4. Do not italicize a signal if it is being used as a verb. Example, for a discussion of the Environmental Protection Agency's failure to interpret a statute to provide intelligible principles, see American Trucking Associations v. United States EPA, 195 F3D4. Order of signals, see the Bluebook, a uniform system of citation. When one or more signals are used, the signals should appear in the following order. A. Introductory signals. 1. No signal, 2 for example, 3. Accord, 4. C, 5. See also, 6. Cf. B. Signals that indicate a useful comparison. 7. Compare. And. With. And. C. Signals that indicate contradiction. 8. Contra, 9. But C, 10. But cf. D. Signal that indicates background material. 11. See generally. When multiple signals are used, the signals must be consistent with the proper order of authorities. Also, signals of the same basic type, supportive, comparative, contradictory, or background, are strung together within a single citation sentence and separated by semicolons. Signals of different types should be grouped in different citation sentences. For example, C mass. BD of ret. B. Merger, 427 U.S. 307. CF Palmer v. Diction, 433 F. Sup. 653. But C. Galt v. Garrison, 569 F2D 993. See generally comment, O unregistered trademark Neal v. Bain, Application of Middle-Level Scrutiny to Old Age Classifications, 127 U par L Rev. 798. When for example is combined with another signal, the placement of the combined signal is determined by the non-EG signal. For example, the combined signal C, for example, should be placed where the C signal would normally fall. However, within a citation clause, citation strings can contain different types of signals. These signals are separated by semicolons. Order of authorities within each signal, see the Bluebook, a Uniform System of Citation. Authorities within each signal are separated by semicolons. If one authority is considerably more helpful or authoritative than the others cited within a signal, it should precede others. Except in this situation, cite authorities in the order in which they are listed below: A. Constitutions and other foundational documents. Cite in the following order: 1. Federal. 2. State. 3. Foreign. 4 foundational documents of the United Nations, the League of Nations, and the European Union. Constitutions of the same jurisdiction are cited in reverse chronological order. B. Statutes. Cite statutes in the following order, according to the jurisdictional hierarchy below: federal, state, foreign, and international. 1. Federal. Statutes in USC, USCA, or USCS. Other statutes currently in force, by reverse chronological order of enactment. Rules of evidence and procedure. Repealed statutes, by reverse chronological order of enactment. 2. State statutes in the current codification. Statutes currently in force but not in the current codification. Rules of evidence and procedure. Repealed statutes. 3. Foreign codes or statutes in the current codification. Statutes currently in force but not in the current codification. Repealed statutes, by reverse chronological order of enactment. C. Treaties and other international agreements, cite in reverse chronological order. D. Cases. Arrange within a signal according to the courts that issued the cited opinions. Cases decided by the same court are arranged in reverse chronological order. Cite cases in the following order, according to the jurisdictional hierarchy below: federal, state, foreign, and international. 1. Federal, Supreme Court, Court of Appeals, Emergency Court of Appeals, and Temporary Emergency Court of Appeals, Court of Claims, Court of Customs and Patent Appeals, and Bankruptcy Appeals Panels. District Courts, Judicial Panel on Multi-District Litigation, and Court of International Trade. District Bankruptcy Courts and Railroad Reorganization Court, Court of Federal Claims, Court of Appeals for the Armed Forces, and Tax Court. Administrative Agencies. 2. State Courts Agencies. 3. Foreign Courts Agencies, alphabetically by jurisdiction and then alphabetically by agency within each jurisdiction. 4. International Court of Justice, Permanent Court of International Justice. Other international tribunals and arbitral panels. E. Legislative materials, cite in the following order: bills and resolutions, committee hearings, reports, documents, and committee prints, floor debates. Cite in reverse chronological order. F. Administrative and executive materials, cite in the following order: federal, executive orders, current Treasury regulations, other regulations in force, proposed rules not in force, repealed materials, state, foreign. G. Resolutions, decisions, and regulations of intergovernmental organizations, cite in the following order: UN and League of Nations, other organizations. H. Records, briefs, and petitions, cited in that order. I. Secondary materials, cite in the following order: uniform codes, model codes, and restatements, books and pamphlets, works in journals, books reviews not written by students, student-written law review materials, annotations, magazine and newspaper articles, working papers, unpublished materials not forthcoming, electronic sources, including Internet sources. For all secondary sources except codes and restatements, cite alphabetically by last name of author. If none, by first word of title. J. Cross-references to the author's own material in text or footnotes, for example, see Arnold v. Runnels, 421 F3D 859, 866 N. 8. United States v. Sellers, 129 F3D 499, 504 N. 3. Overruled on other grounds by United States v. Johnson, 256 F3D 895. Evans v. Demosthenes, 98 F3D 1174, 1176. Parenthetical information, use parentheticals, as need, to explain the relevance of a particular authority to the proposition given in the text. Parenthetical information is recommended when the relevance of a cited authority might not otherwise be clear to the reader. Explanatory information takes the form of a present participle phrase, a quoted sentence, or a short statement that is appropriate in context. Unlike the other signals, it follows immediately after the full citation. It usually is brief, about one sentence, and provides a quick explanation of how the citation either supports or is in disagreement with the proposition. For example, Brown v. Board of Education, 347 U.S. 483. Equals phrases not quoting the authority equals, explanatory parenthetical phrases not directly quoting the authority usually begin with a present participle and should never begin with a capital letter. See generally John Copeland Nagel and J. B. Rill, The Law of Biodiversity and Ecosystem Management 227-45. Booz v. Barry, 485 U.S. 312, 318. See generally Ackle Reed Emma, Reports of My Death Are Greatly Exaggerated, a reply, 138 UPAR L. Rev. 1651. C. For example, Environmental Defense Fund, Incorporated v. Hardin, 138 U.S. App DC. 391, 395, 428 F2D 1093, 1097. See Verizon MD. Incorporated, 535 U.S. 635, 644 N3, 152 L Ed 2D 871, 122 S. Connecticut, 1753. When a complete participial phrase is unnecessary in context, a shorter parenthetical may be substituted. Such standards have been adopted to address a variety of environmental problems. See, for example, H. B. Jacobini, The New International Sanitary Regulations, 46 MJ International L 727, 727-28, 1952. Robert L. Mayer, Travaux Préparatoires for the UNESCO World Heritage Convention, 2 Earth LJ. 45, 45-81. Equals phrases quoting the authority equals, if the parenthetical quotes one or more full sentences, then the parenthetical should begin with a capital letter and end with punctuation. Example. See Committee Note to Interim Rule 8001, F. 1, provides that entry of a certification on the docket does not occur until an effective appeal is taken under Rule 8003, A, or. Punctuation and spacing, insert one space before the opening parenthesis of the explanatory parenthetical. Note that if the parenthetical does not contain a complete sentence, the writer should not place final punctuation, such as a period, inside the parenthetical. Additionally, in legal writing it is permissible to nest several levels of parenthetical material, and it is also permissible for parentheses pointing the same way to kiss. However, never have two parentheses pointing in different ways about each other. Always use a space between them. Place a parenthetical that must be included as part of a citation before an explanatory parenthetical. Example: Fed. Our sieve. Pages 30, 1. Shorter parenthetical phrases may be used if a complete participial phrase is unnecessary given the context of the citation. Example: The Florida Supreme Court recently declared that where the seller of a home knows facts materially affecting the value of the property which are not readily observable and are not known to the buyer, the seller is under a duty to disclose them to the buyer. Johnson v. Davis, 480 So 2d 625, 629. The rule in this state continues to be that professional baileys may not limit their liability for negligence. In every instance where a disclaimer of liability has been invalidated, a professional bailee was involved. See Althoff v. System Garages, Incorporated, Supra at 864. Ramsden v. Grimshaw, 23 WN2D 864, 866, 162 pages 2D 901. How do I determine whether my argument needs a parenthetical? 1. If your source directly quotes or supports your argument, then you probably do not need a parenthetical. 2. Do you have multiple arguments or points occurring in that portion of the text? If yes, then parentheticals may clarify how those sources individually contribute to the argument. 3. Are you citing to a broad or dense source? If yes, then a parenthetical that points to the correct and specific information might be helpful. Order within a citation equals, if the case you are citing has some subsequent history or other related authority that needs to be included, it should come after your parenthetical. Example: Anderson v. Terhune, 467 F3D 1208, Ray N. Bank granted, 486 F3D 1115. Be careful of. 1. Vague or broad parentheticals that do not add any additional value, the reader would not know anything more or less if it was not there. For example, addresses tort reform. Internal cross-references, portions of text, footnotes, and groups of authorities within the piece may be cited using supra or infra. Use supra to refer back to material that has already appeared within the piece. Use infra to refer to material that appears later in the piece. Note and part are used to refer to footnotes and parts within the same piece. P and PP are used to refer to other pages within the same piece. The Bluebook, a uniform system of citation. However, avoid heavy usage of infra, supra, opsit, loxit, and similar abbreviations that refer to citations that appear elsewhere in the writing. These forms burden readers by forcing them to hunt for the full citation elsewhere in the work. Generally, these abbreviations should be used sparingly and only to avoid repeating a lengthy footnote and/or to cross-reference a nearby footnote. A list of internal cross-reference forms. See Supratext accompanying notes 201-02, see Supra notes 11-12, 45-46 and accompanying text. See cases cited Supra note 12. But see Supra part VAC. See infra pages 11-12, see infra pages 98 and note 123. Supra is used as an internal cross-reference to guide the reader between parts of a document, whether text or footnotes. You may combine supra with note, part, P, or PP to refer to footnotes, parts, or pages within the same piece. Use supra when the authority has already been cited in full, and add the short form for that authority. Supra may be used alone with the short form, when referring to authority within the same footnote when it would not be appropriate. May combine supra with signals. Do not use PP as part of the short form for any authority. Do not use supra with cases, statutes, constitutions, legislative materials other than hearings, restatements, model codes, or regulations unless the name of the authority is extremely long. Supra references. Example, Ginsburg, Supra Note 43, at 1485. Use supra with a OE note a to indicate a footnote within the same piece. Notice that you need a comma after the supra clause. You may combine supra with a signal and other text. The signal would be italicized but the text explaining where to look is in ordinary type. Infra, use infra to refer to discussion or footnote content after the current footnote or text. Always combine infra with note, part, p, or pp to refer to footnotes, parts, or pages within the same piece. May combine infra with signals, do not use infra for citations to authority. Infra references. Example, nevertheless, the cases holding that the server's behavior constitutes distribution seem justifiable. See infra note 76 and accompanying text. Infra usually follows a signal. The signal and infra are italicized, but the rest of the text is not. Infra may also follow text after a signal, as appropriate. Anything other than infra or the signal would appear in ordinary type. Compare ALWD 10 and Bluebook 3.5, the rules are very similar, but under the Bluebook, spell out a OE note a or a OE part a BB infra note 45 and accompanying text. ALWD, infra N. 45 and accompanying text. See also, Oxford Standard for Citation of Legal Authorities or OSCA, Legal Citation, the Bluebook, a Uniform System of Citation. References. Bibliography, Signals Bluebook from Suffolk Law Library, a section 6-300. Signals in Introduction to Basic Legal Citation by Peter W. Martin from Cornell Law Legal Information Institute. External links, Legal Citation, MLA-style Bibliographic Citation Guide, MLA format for academic papers, Gallagher Law Library's Bluebook 101, Introductory Signals, Introduction to Basic Legal Citation.